My research reveals that the defense's medical expert was convicted of Medicare fraud. Can I use that at trial to show to the jury that this medical expert is a liar? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, I can. I can show to the jury that this doctor has a storied history. I can show to the jury that this doctor is a convicted felon. I can show to the jury and expose the fact that here they bring in this medical doctor to go ahead and testify and claim that they did nothing wrong, when in fact I can show to the jury what we call a collateral attack, an attack on the doctor's history, an attack on the doctor's credentials, to show that this doctor is not believable. Now, when I ask the doctor whether he's ever been convicted of a crime, if he says no, then his testimony is basically over. Why? Because now I'm going to go after him and hit him over and over and over again with the fact that he's a convicted felon and he failed to tell the jury the truth when I just asked him that question. On the other hand, if the doctor goes ahead and admits on the witness stand that he was convicted of Medicare fraud, now I've exposed the fact that this doctor at one point in time was a liar. Maybe not now, but at one point in time. And as a result of that process, as a result of that problem, he was convicted of a felony for lying to Medicare. And now I can argue to the jury later on during closing arguments, hey, this doctor is not to be believed. This guy is a liar. The defense attorney will likely tell the jury during closing arguments, listen, that what happened in the past is in the past and has nothing to do with the issues in this case dealing with the medicine. And the guy still has good credentials and he's still a good doctor. Now the jury has to decide who they believe. And you should know that at the end of the trial, the judge gives the jury legal instructions. And one of those instructions has a fancy legal term called falsus in uno. And what does that mean? It means that if the jury finds that a witness has testified falsely about one thing, they have the legal right to disregard all of that witness's testimony. So, when I bring out the fact that this doctor has lied in the past, and as a result of those lies now suffered a conviction, a felony conviction, the jury can take that into account to decide whether or not he's believable on the issues in this case. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.